I am accompanied by Gillian Trainer. Very kindly has agreed to join this webinar with me. We're going to give it a minute or two for people. People are still joining. We can see here by the numbers. So while we're waiting for that, I'll go on ahead and introduce myself and just go through a few housekeeping points. The session, as you can see, is being recorded. The recording should be available in about 24 hours, and you'll find out about that. And then in terms of questions, we will, if you want to put them directly into the chat, we won't be able to take them in person, but if you could please put them into the chat, Gillian will be keeping an eye on it and myself, and then we'll try and take them either throughout the session, but certainly at the end, we'll leave time. I am very mindful that this is lunchtime for everybody, so we will definitely try to be very, very punctual and to give you time to go and get a bite to eat as well before you go back to your day jobs. So thank you again for joining. In terms of then just an introduction in terms of myself, hopefully everybody can see the slides. So I'll just talk through myself. I'm the DPO for Cairn Group. I've been an in-house DPO now for almost 8 years, almost always within the asset management industry. For those of you who aren't familiar with Cairn Group, it's an Irish business. It was founded in 2004, so we're actually celebrating our 21st birthday at the moment. We're Europe's largest independent third-party management company, partnering with about 650 clients worldwide with funds in over 160 countries, and we oversee over $2 trillion in assets under management. We've got about 600 employees and they're spread across 8 locations globally. So I'd say that makes me pretty busy, mostly on a day-to-day basis. I was delighted to be able to step away from the day job and join you all here today. Gillian, if you could introduce yourself, please.
Yeah, thanks a million, Lisa. I'm delighted to join it today, and thanks to everybody for joining. So my name is Gillian Trainer. I am co-founder and director of our company. It's a data protection consultancy firm, Ambit Compliance. Some of you may have heard of us. We work with public and private sector clients and charities also in regard to data protection. Also, we help with e-privacy, GDPR data protection compliance, and for charities also charities governance code compliance. So I'm delighted to join Lisa today to discuss this evolving topic, and I think that's one of the themes we'll probably discuss later on and probably will come through in our questions. So as we kick off, Lisa, I think I'd like to know, and maybe the audience would like to know, what is of particular interest to you in this topic, or why this topic claims for material damages?
Thanks, Gillian.
Sorry, non-material damages.
Non-material damages, exactly. Thanks, Gillian. So as part of the executive committee for ADPO, when we were discussing possible material for this, I put this one forward. And the reason for that was really because it really is where the rubber meets the road. And as we watch these, and we should all be doing it, and I'm sure I'm preaching to the converted here, we should all be watching these to see the direction of travel of the judicial system in this, especially within Europe, where each regulator and each entity and each judicial system is looking to its neighbours to see what they're doing in similar cases, so that we get a consistent look and feel. There's going to be a big change, I think, in the landscape over the next 12 months. And it's probably one of the things, maybe as we're working through this, if the audience could give us a feel for if it's something that, if we see a material change in the next year, whether we'd revisit this in 12 months' time. So with that, I'll move straight on, if that's okay, into, I guess, some of the landmark cases. Most of these you'll be familiar with, so apologies if I'm telling you stuff that you already know. But C34021, which was this was a case with the Bulgarian tax authority where they suffered a cyber attack. Now, what I think is really interesting in this case is that this actually initially went to the administrative court, Sofia, and they dismissed the action on the basis that the controller didn't cause the breach because it was actually a third party who was processing on their behalf. Now, it was then brought to the Supreme Administrative Court of Bulgaria, and they referred it on to the CJEU, who then ultimately found that the controller is absolutely responsible for the TOMs, or technical and organizational measures, of its sub-processors. So that was an interesting case in terms of understanding that, you know, all the good Article 28 stuff, that we must make sure that everybody that's acting on our behalf and that's processing data on our behalf applies the same rigor and controls. Another interesting one, this is one all of you will have heard of, the Österreicher Post case, C321. So this was a case where the data subject was seeking 1,000 in compensation for the processing. So they were basically upset at the political affinity that was attributed to them by virtue of data scraped by the Austrian Post service. Now, what's probably critical with this one is that it really set down the three-step criteria that we've seen now almost consistently applied across the across all cases. So the three steps are: there has to be a breach of the GDPR, there has to be damage suffered, and there has to be a causal link between the breach and the actual damage suffered. So it was one of the first cases that really laid down that measure. And then we had the Gemeinde Ummendorf, and apologies to people if I'm butchering the pronunciation on any of these. So this was for non-material damages. Again, it confirmed the ruling of the Österreicher Post case again, but this was actually the municipality of Ummendorf published meeting minutes and a judgment of the administrative court of Sigmaringen on their website. Now, it was only there briefly. They pulled it down quite quickly. But what was interesting was the two data subjects and the judgment. Their details were not redacted, although there was a lot of other details within the case that were redacted. So in that case, they took that case and they were successful again in that particular case. So even though the details were removed and were only available for a short period of time, the CJEU ruled that there's no de minimis threshold for damages below which an individual cannot claim. And that was quite critical. And they actually went so far as to say, the CJEU said, you can't, like, it would actually be fundamentally in breach of the GDPR to put a de minimis threshold in there.
Interesting, Lisa, is that I think in the UK there's been some cases where the de minimis threshold has been applied, or they've stated, but it's quite clear here, particularly from the Österreichische Post case. And actually, on those three conditions that you mentioned, one of them is there obviously must be a breach of the GDPR. So if there's breach of multiple articles or provisions of the GDPR, does that create in any way a multiplier effect in terms of the claim?
It would be nice to think so, but actually no. And there is a precedent case in GP versus Juris, so that's 741/21. And there they ruled that where one processing activity infringes multiple provisions, it doesn't allow for double counting, basically. So that was a client of Juris, which is a company that operates a legal database. They learned that their data was being used for direct marketing. They actually revoked their consent and then subsequently continued to receive material. So they were in breach of, I believe it was Articles 29, 82 and 83. And it was in that case in particular that they said, no, you can only apply that basically the damage doesn't multiply based on the article multiplier.
Yeah. Whereas it doesn't need to be a data breach in terms of the definition as we understand it in the GDPR. It's a breach of one of the articles or multiple articles where there is considered to be a breach of the GDPR, I suppose it needs to be clear. And has there been any scenarios where people have been unsuccessful in their claims?
Indeed, and for multiple reasons. So we'll pull out two here that might be of interest to everybody. So there was the Mediamarkt Saturn case. Again, a lot of you may be familiar with this. This one always, because I can actually visualize this one happening. The data subject bought a household appliance, entered into a payment contract with the controller, and then while they were at the checkout desk, another individual slipped in front of them and actually collected both the appliance and the contract. And left the store. Now, an employee quickly realized it, and they were able to reclaim the appliance and the contract within half an hour, and there was absolutely no evidence of misuse. So in that case, the controller offered to compensate the complainant by sending the appliance free of charge, but the complainant refused. The CJEU in that case ruled that the complainant has to be able to prove a negative consequence or damage, and that the damage can't be hypothetical. So in that case, or based on just mere fear. So in that case, there was no award. There was also another interesting case with Scalable Capital. Now, in this one, there was a symbolic award, but this was one where they were actually taking a case for identity theft, but actually there was no ability to prove that there had been identity theft. So it was a trading application. The data subject opened accounts and entered personal data, and then the personal data was seized by third parties whose entities were never identified. According to the controller, the data had not been used fraudulently, but the data subject brought the action in any case to the local court in Germany seeking compensation. And in that case, because they couldn't prove that there was identity theft, they still said compensation could be claimed for theft, but not identity theft. So they awarded a symbolic. We'll see also later on, when we come to some of the Irish cases as well, that interestingly in Ireland, there's a precedent for looking to have an application through the injuries board rather than before they bring a claim against the GDPR. So that would be a really interesting watch, but we'll come on to those cases.
Yeah. And are there any particular kind of common threads that we can see through these cases that have been, or claims that have been brought?
For sure. And actually the CJEU has thankfully almost consolidated those quite recently to provide guidance for controllers. So obviously we've talked about the criteria. So again, just to reiterate the 3 criteria, there has to be a breach, there has to be damage, and there has to be a causal link between the breach and the damage. And as we've said, the scope of the non-material damage, so the CJEU has expanded the scope to include fears of future misuse of data as compensable harm. So even the anxiety or the stress caused by potential future misuse can be grounds for a claim. Also the severity threshold. So as we've established, there can be no de minimis. There can't be a minimum level that has to be reached in order for somebody to take a case. And then the uniform application piece as well. So the concept that that's defined at an EU level to make sure that there's consistent application across all member states within the EU. So really what these rulings ensure is that that basically individuals can claim for emotional distress or reputational harm, and that they don't need to prove a certain level of severity in order to take that case. So that's probably one of the critical pieces.
Mm-hmm. Particular interest, I'm sure, to most of our audience is, the Irish context, and particularly what's happening and what they might want to advise their CEOs or boards of management or boards of directors. So maybe talk us through. There's quite a few here actually, and there's a few more we're going to talk about.
This is a very wordy slide. Sorry about that one. So yeah, lots of material here, and this is actually, as a company headquartered in Ireland, this is something that I've shared with my boards as well, because they're very interested, again, because it's where the rubber meets the road. So Keane versus the CSO, some of you may be familiar with this case. This was a plaintiff who was employed as a census enumerator, and the CSO erroneously disclosed their P45 details as part of a broader disclosure. So in that case, they were bringing the case for anxiety and distress that she suffered. Now, this was one where the circuit court actually found that it should have gone through the Personal Injuries Assessment Board, which was, well, now the Personal Injuries Resolution Board. So apologies, I'm going to be using it interchangeably because sometimes the ruling was when it was under its old name. But that they should have brought the application there before commencing with proceedings, and the High Court upheld that, ruling that they should have gone to the PIRB before commencing the proceedings. I think this is something we're really going to need to watch here and see, will there be instances, because there is one further down that you'll see where that requirement wasn't in there. The other one there is Dillon versus Irish Life Assurance. So this was where the plaintiff had a life insurance policy and a number of letters related to the policy, and they were actually disclosed over to a third party over an extended period of time. And again, the plaintiff basically was taking distress, upset, anxiety, inconvenience, loss, and the actual damage itself. So the circuit court dismissed the proceedings on the basis that prior authorization hadn't been obtained from the PIRB as required. And the plaintiff appealed that decision, arguing that the claim was a claim for non-material damages pursuant to the GDPR. But the High Court upheld the decision of the Circuit Court and found again that the nature of them warranted recourse through the PIOB or PIAB. One where we didn't see that is quite a distressing case, actually, MH versus the Child and Family Agency. So this was one where a plaintiff issued proceedings for damages for a breach caused by negligence. So this was basically abuse that they had suffered was disclosed to family members of the plaintiff, and the plaintiff alleged that it caused damage to her relationship with her family and that she suffered upset and distress rather. So the decision very much does not follow the Keane and Dillon cases that we see before that. So the court didn't require PRIB, but equally it didn't require medical evidence of the plaintiff's mental state or an assessment from a medical professional. They accepted the plaintiff's testimony in that case of the stress and trauma. And this was one of the higher awards that's gone out from an Irish court at $7,500 for non-material damages. So it should also be noted that the defendant hadn't taken any steps. And that's probably a really critical thing that we'll see throughout these. An apology and remedial action can make a big difference in terms of the ruling and the sympathy of the court in relation to these.
Yeah, and actually there was another one, and we didn't want to put it all on the slides because it would be even more words, but there was one of the first cases in Ireland to be successful in the courts for claim of non-material damages was a chap called Kaminsky, and it's regularly referred now to as the Kaminsky case versus Ballymaguire Foods, their food manufacturing facility in Ireland. And he got an award of approximately, I think it was €2,000. So this was the first one in Ireland, but there was a wait in a lot of cases. There was some other cases afoot, but they were waiting for the CJEU to finalise the Österreichische Post case, so they could then use that guidance, so to speak. So similarly to what Lisa just said about the MH versus Child and Family Agency, no medical evidence was provided, or indeed was needed to be provided, because the judges in both cases found that the testimony of the plaintiff was sufficient for them to award. And the judge in that particular case, in the Kaminsky case, also mentioned that obviously the conditions that the Austrian Post case had mentioned, but also it said non-material damage must be genuine and not speculative. So in other words, again, that it can be proven. Damage must be proved, and supporting evidence is strongly desirable. Now, as we mentioned, the evidence here was sufficient for it to be the testimony, but it is possible that they would look for medical evidence. And then, as Lisa mentioned there about mitigating factors, the judge in that case also stated that an apology where appropriate may be considered as mitigation. So when we're dealing with any of these cases as data controllers, before, and hopefully before they ever get to the court, is how we handle a scenario. And I think we're going to go on to the next slide shortly to kind of consolidate what have we learned so far in terms of from those cases. And as we kind of move on through the presentation, what can we take away to our own organisations or colleagues to advise?
Absolutely, Gillian. And actually, just while you're on that, if you don't mind, it's not in the material, but it's just something I just read actually yesterday. I don't know if, I'm sure some of you in the audience have also seen it in the Decathlon case in Romania, another CCTV case, another case where they were using it for disciplinary investigation as opposed to, which was totally in contravention with their privacy notice. So I guess it comes down to, now that's actually a GDPR ruling. They were fined 5,000, which doesn't seem to be even a fraction of what I suspect Decathlon's annual turnover is. But anyway, one of the things, I guess, what is so critical, and what I'm seeing more and more with rulings and with claims for non-material damages, is your privacy notice is one thing, but also having your acceptable use policy, your CCTV policy, making sure that they're all in sync with each other and that they're all available. Because one of the cases that I've seen recently where not only was the acceptable use policy, they had one, but they didn't make it available to the employees. So they didn't know what they were supposed to be doing. And that was a case where somebody had a trading platform on their personal phone. And then the phone was hacked. And that was actually somebody in the HSE. They were part of the cyber attack, and their phone was hacked, and they lost access to their trading platform, and they took the case. But because they were in breach of the acceptable use policy, there was an issue.
But before you move on, Lisa, actually, I'll just give a very brief overview, because whilst we mentioned Kaminsky, not everybody may know that it was a misuse of CCTV case whereby Mr. Kaminsky was an employee and footage of him not being terribly compliant with health and safety protocols was used as a piece of training material as to how not to conduct oneself in the workplace. He was also in that training session, did not know it was going to be used, and naturally felt the ridicule, etc., of his, and he had numerous other issues on foot of that. So it, I'm sure any of you who use, or you're as DPOs, are looking after or overseeing CCTV usage, know how contentious it can be in the workplace and how policies and procedures can not always be adhered to. So it's just a case in point for anybody that really wants to hammer home to their management that the misuse of CCTV can have devastating consequences. And whilst the values, and you might look at all of these values and say they're not really very large, and maybe, but we have to consider also, as we will, as we go through the rest of the presentation, the cost in time and resources, and solicitors' fees that an organisation will have to put to defend these types of cases. So I suppose it's something to keep in mind.
And I would add to that as well, Gillian, there's absolutely, you're right, the cost and the time, but then there's the reputational damage, because unfortunately now Ballymaguire Foods is what, you know, when I think of that, I think of the Kaminsky case. Now, not everybody be as familiar with it as this audience would be, but there's that aspect to it as well. And also, especially if it goes to the point of being a ruling, then you're on trackers, you're on registers. And for anyone here who works a lot with, you know, due diligence questionnaires from clients, one of the first questions on nearly every due diligence questionnaire that I get is, have you had any rulings against you in relation to GDPR? And you do not want to be answering yes to that question, because they'll just move on to another company. So moving on then, I guess we've talked a lot about this, but there's a few kind of key takeaways. So we'll just summarize those and then go on to maybe some practical steps that we can all take. The cumulative requirement, I'm not going to overly labor it. It's those three-step criteria: the breach, the damage, and then the causal link. The duty of proof, and this is one that I find really interesting, is that data subjects still have to prove that the breach of the GDPR did cause non-material damage. So fear associated with the disclosure can give rise to a right to compensation, but the fear has to be proven. And then the burden of proof. So for adequacy of the security measures, that lies with the data controller and the processor. So the burden of proof of the actual harm or the damage lies with the data subject, but the burden of the evidence in terms of technical and organizational measures very much lies with the data controller. It's that ultimate responsibility. They can't pass it off to the data processor. They can't say that was a third party that was operating on my behalf. They must still remain responsible. And then the liability for breaches by third parties, so data controllers can't avoid by relying on the negligence or failure of another authority. As we saw, for now, and I say for now because this could change, a claimant has to secure prior authorization from the Injuries Resolution Board in Ireland before bringing court proceedings. I think we need to watch that one and wait and see how that plays out over the next year, because as we saw in the latter case against Tusla, that wasn't required. So there seems to be some flexibility and movement on that. And then actions by the data controller to mitigate or remediate will be taken into consideration. And I think that is critical. It's one of the things that I say to my boards, is that as much as we will be judged by the mistakes we make, we will certainly be judged by the response to them. And that has to be appropriate and measured and full and robust as possible. And then in terms of Article 82, we've already discussed it, that de minimis threshold. So there is none, because it would actually, making compensation subject to a certain threshold would risk undermining the whole coherence of the rules of the GDPR. As we see, the damages in the Irish courts between 500 and 7,500. So we say not excessive, but again, it's time, it's money, it's legal fees, but also it's reputational damage as well that are at risk there.
So in terms of, I actually might be useful even just to reference this now. It wasn't a direct claim, but people will be familiar with seeing it in the news or on the papers recently, where the Bank of Ireland settled in the High Court Now, with no admission of liability directly in regard to a lady's data that was breached and leaked to her estranged father, which meant that he could then pursue her to her new location. So they settled out of court or within the courts, but not with admission of liability for €350,000. So, these are costly endeavours, whether you're settling. And I suppose that's another question. There's possibly, whilst the GDPR came into force in 2018, the Österreichische Post case was 2023. So that's when we started seeing all of these other cases coming through because we had some guidance. So it took that 6-year period. It's hard to know, isn't it, except anything we've heard anecdotally, as to whether controllers are settling outside of court when a data subject comes to them with a complaint or a breach or a loss of their data.
Absolutely. I think it's probably safe to say that they are. I think also what we're probably going to see is a flurry of class actions coming now, especially on foot of the big fines that are coming down from, well, the Lux and the Irish regulators probably are two of the really heavy hitters in that space. So I think we're probably going to see them. I know NOYB, so Max Schrems, not-for-profit organization, has indicated that they would be facilitating class cases. So I'd say we're probably almost certainly going to start seeing some of those coming through the court.
It's unusual we haven't seen any to date because they're quite prolific in what they do. But as we know that through the GDPR, that there is a right to a non-profit organisation can represent data subjects. So I'm sure that will happen in due course. So what can we do, Lisa? We've talked a lot about what we should be aware of, but I suppose in practical terms, going back to our workplaces, speaking to our boards, our management, what are the messages that we need to take home with them?
Sure. Thanks, Gillian. Obviously, keep doing the day job, keep being compliant, keep monitoring compliance, and taking the remedial actions. A few key things in terms of the recommendations is just making sure there's an understanding of the causality. That duty of proof, what can we do about that? That really ties in with your risk management and insurance, and strengthening those processes, your enterprise risk management framework, making sure that things are flagged and that you have an appropriate plan to mitigate any identified risks, and then reviewing your insurance policies to cover potential liability risks and making sure you have appropriate cover in place around those. On the burden of proof piece, as we said, that's the TOMS, technical and organizational measures. So the judgments that we saw consistently call for companies to rethink their strategies on foot of this, and to ensure that they have effective security measures, not just them, but also the third parties that process or the sub-processors that process. So this is back to that, all that good stuff, the accountability principle, precise documentation, willingness to be able to prove the suitability of measures that are in place, and being able to evidence them on request and on demand. All of the good stuff that's in Article 28 anyway, but really just making sure that we get into our vendor management piece and make sure that that's robust. On the liability for breaches, there could be legal adjustments that are needed, right? So DPOs may need to look at your data, your policies, your procedures, but also your legal agreements to align them with the latest requirements, and make sure that you can't contract yourself out of liability, but on the basis of this. And then in terms of the actions by the data controller, like to looking at the courts, incident response plans, that's what they're going to expect to see. So making sure that you have a playbook, that you've tested it, that you understand, that you know, that you update it as well, that it doesn't reference, the Privacy Shield or whatever else it may be. So making sure that you have a robust and tested run book for all incident response, and that you then continuous monitoring and adaptation, just making sure, like all of you are doing here today, stay close to what's happening, keep an eye on the rulings, understand what they mean for you and your business and your role. And then training and awareness, really just investing in good training programs. I'm in the middle of mine. I was in our Wexford office on Monday. I'm in our London office next Monday. And all of that is documented. And I make sure that literally there's lists of attendees, so I can go and say with confidence to our clients, yes, I know that everybody in the company has received this training. And the other thing, I guess, over and above all this is taking this to your boards, making sure they're aware of this, making sure they're aware of these cases. You can actually use this to your advantage, right? If you're finding that you're not getting the budget or the resources or the time or the support that you need, this is the frightener. This is the kicker where you kind of say, well, this is what happened. And guess what? It could be us.
Absolutely. So yeah, and one interesting thing that I just came to mind there when we're talking about those monetary awards, that there's been a slight change. You mentioned the change whereby it needs to go, a lot of civil actions need to go for injury, personal injuries will need to go to the PIRB, but also there's been a slight change, and the legislation is the Courts and Civil Law Miscellaneous Provisions Act of 2023 has said that now data protection cases can be heard in the district court as opposed to the circuit court. And the district court has a lower ceiling of awards up to €15,000. So it does look likely that if there is any other compensation that they're going to be lower. But as I say, we've seen that they are quite low, really, particularly the one there with against the Child and Family Agency. One could argue it is quite low given the severe distress, but the award in itself is, I suppose, symbolic and significant.
Yeah, and I think that movement to the district court from the circuit court, because of the significant reduction in legal costs that will bring, we'll see a flurry of cases now. As you say, the payouts may be lower, but I think we'll certainly see the volume of cases increase.
Absolutely.
There's less barrier to entry there.
So I'm just going to remind the audience that if they want to pop any questions into the chat, they can do, and we can answer them. We're also interested in knowing if, you know, as Lisa mentioned, there is likely to be a lot of movement on this, we imagine, in the next 6 to 12 months. And if there's an appetite for us to revisit this type of thing again at the beginning of next year, please do let us know, and we would do another presentation. As we can see, I think the Germans seem to be quite active in this area, and I think the fact that they've got numerous data protection agencies, the supervisory authorities, also kind of speaks to that. But in the cases that we've seen, quite a lot of them are German, aren't they?
Yeah, for sure. I did see a couple of questions there. People are asking for a copy of the slides. I have no issue with providing the material unless anybody feels differently, but I certainly have. It's not copyrighted or anything. Yeah. So,
yeah. That's right, and there will be a recording also available as well after this, and that'll be emailed to you or linked to it. One of the attendees has mentioned that there would definitely be an appetite for this content again, and they found it very useful. Thank you, Lisa. So as I say, we've got some time if anybody wants to ask any remaining questions. But I suppose it's a really interesting topic. It is absolutely, as you said, Lisa, it's absolutely something that we need to be advising boards and management on, because I think they, you know, there is a feeling out there that the GDPR has had no teeth, and the DPC are slow to move on things and are only focused on the large organisations, and it's not the fact that that is the case, and also that there is people are aware of their rights and will pursue them, and rightly so. So I think this is something that everybody in management responsibility should be aware of.
Yeah, and Gillian, I just saw one other question, and it's a really good question, and we see it come through in surveys after survey after survey. What can DPOs do if they're not being provided with resources to do their jobs? Oh Lord, do I wish I had a silver bullet for this one. It's a really, really challenging one, and thanks for asking it. There is definitely an evangelical part to being a DPO, right? You've got to understand that if the traditional channels within your organization aren't proving to be amenable to you, then maybe try and look for some informal channels. stakeholders who might not be on the org chart as being stakeholders, but actually have sway at senior management level, and see if you can engage them. And the other side of it is that, you know, we are enshrined by law, and they're, under the GDPR, they have to provide sufficient resources and budget and time and training and ongoing learning to us. So making sure that the senior management team are aware of that. It was an anonymous question, so I don't know who it was, but it sounds like possibly your reporting line might not be what it should be, because you should be reporting to the highest level of management available. So if that's wrong, then you have the obligation to make sure you point that out to your employer, because actually it's on them to make sure that you're afforded that reporting line. So, and that person should be amenable and should be understanding of the role. The fact that they've actually appointed a DPO means that there's obviously some willingness there. So maybe making sure that the reporting line is correct. Would you add anything, Gillian?
Yeah, no, I'd reiterate what you've said, and actually I think it might be the same individual that's just added the following, and I'll speak to it as well afterwards. Is the DPC has recently confirmed at a civil service DPO network meeting that they are currently developing guidance for DPOs to assist them with in terms of resourcing. So I would agree entirely, Lisa, what you're saying. I do think people naturally are fearful within their jobs. We have to be reminded that the DPO cannot be dismissed for trying to do their jobs, which is also enshrined in the legislation and in the DPP guidance. So I would, you know, it is a risk. I don't know whether one could be so bold as to say it needed to be added to the risk register, the fact that the DPO has insufficient resources. But like you said, try and get to speak to the right people. But and I would perhaps seek in an anonymous fashion, maybe advice from the DPC too, if possible. So we have a few other questions I'm going to read out. Do you foresee more claims similar in size to the Bank of Ireland one in the future? So maybe I'll speak to that first, because when I read the headlines initially, I thought it was an admission of liability. I thought it was an award of the court, but it was something that was agreed, but it was not. It was not. They did not admit that they had caused a data breach, and that was 350k that they decided they were willing to pay under the guidance of the court. It's hard to know. As I say, that wasn't the court awarding it, that was some sort of settlement made. So it is a little bit different. It does seem quite sizable, to be fair. So I don't know, Lisa, do you have any thoughts on whether you'd see anything quite that large, 350k, mindful that it was in the High Court, and the costs of bringing that to the High Court are significant?
I think the level of it is pretty significant, and I think all variables would need to be the same for us to see some similar rulings coming out. There was an interesting question from Tim there. If you were to make a compensation payment, what criteria should be used to judge the amount that should be paid? Really great question. So, you know, essentially, if you were asking, you know, probably your CEO or your CFO that question, it's like it'll come down to how much is it going to make them go away, right? That's what they're going to ask. But what I would be, from a DPO perspective, where you really are looking after the interests of the data subject, I think what you need to consider is factors like, how much is it going to cost if this goes to court? What are we going to be paying out in our legal fees? What's this going to do to our reputational damage? And what is the level of hurt that this person has actually suffered, or the level of damage or fear or whatever else it might be, and use those as criteria in terms of defining what you can. But essentially, you know, in your discussions with your CFO and your CEO, basically you're saying, guys, you're going to pay a lot more in legal costs than you're going to pay out if you write a check. So I think that's your argument back to them.
So just carrying on from what you mentioned, Lisa, but maybe you'll speak to it again. A query has come in here. Is the highest management level the director or the CEO, or is it the next level down at the level of chief operations officer? And now I know this is close to your heart because you have that direct line to the sky, which is where you need it. So if you
yeah, of course. Yeah, I'll take that one, Gillian.
Them know.
So essentially, and this is when I'm doing my induction training with our new hires, it's one of the pieces that they love, is that whilst I report to our Chief Compliance Officer, so I'll give my own example, but he sits on the Global Executive Committee, so he has that direct line. That said, I report directly to the boards we have 15 different legal entities within Cairn, and I report directly to those boards. Nobody sees my pack before I present it to the board. Nobody can interfere with it. They can't tell me it's a bit salty or they want me to tone it down or whatever else. Nobody can do that within the company. So the line, the reporting line is one thing, but if they're then telling you or somehow trying to curb the message that you're getting across to that senior level of management, that's where you have the issue. So you need to make sure that that's the right level. I can't really say whether COO is appropriate because, well, COO, Chief Operating Officer, is typically going to process data. So I would think that COO could be a challenging reporting line. Unless they absolutely have no processing of data involved in their role, I don't see how that would work. But I don't understand the nuances of your particular industry, obviously.
I think it's interesting. It's an interesting question because practically sometimes there is a kind of an operational reporting line, but I think it's crucial, Lisa, like what you said, that there is the reports that might be addressed to the CEO in the first instance, but also intended for the board, and it is shared, and that there is an open door for the DPO to do quarterly or annual presentations to the board, so they are quite clear that it's well governed, and that's really key.
And I might add one thing as well, Gillian, is that if you're in doubt, if you go onto the GDPR tracker and the enforcement tracker website, you can filter by article. So if you look under the article for the appointment of a DPO, you can see rulings on that, and that will give you a clear line of sight. And if you think that any of those rulings are kind of red flags, then that will support your argument for going back to your current management line and saying, this might not be working. I may need to reroute, or we may need to change my reporting line. And again, the way I always look at this is try to put yourself in the shoes of a regulator coming in. Could you defend your reporting line if you were in front of the DPC or whoever else your lead supervisory authority is? And if the answer is you'd struggle, then maybe you need to change something.
There's another one here. I'm going to read it out, but we may need to do a second read because it's lengthy. When a data subject requests compensation for stress, anxiety, damage to career prospects, etc., would it be appropriate for the controller to ask for medical evidence? And if so, could it be from an independent consultant? Have I got the entirety of it?
I get what you're asking. Yeah. So okay.
Or rather than their own GP. So in other words, this must be a direct request for compensation, which would be somebody trying to settle with their employer, probably more likely, or data controller, depending.
Yeah, exactly. So typically, and this is definitely one for your legal counsel, right? To make sure that they understand. But you are within your rights if they're claiming they have anxiety or stress. You have the right to request medical evidence of that, but definitely it should all go through your legal counsel. It shouldn't be going through the privacy office, because it sounds like that's a litigation case anyway. So your legal counsel should be fully engaged on that one.
So let me just have a very quick look to see if I hopefully I haven't missed anything. I think it's great to see all the questions and all the interest. Because that's where the real value I always find is in these sessions. So if there's any last questions, guys, please do pop them in. I think that's everyone there. Kieran from the Association of Data Protection Officers, our colleague, has also put a link to the NOIB in there, and to say that it's now qualified to bring collective redress actions in Ireland and elsewhere in the EU. So I think watch that space, definitely.
And it sounds like we have interest in a repeat. So we'll see once we have enough kind of content to redo this, we'll look at scheduling something in the future as well. So it's good to know. Thanks.
So I think we can.
Then I definitely owe Gillian a huge thanks. I owe everybody thanks for your patience, for bearing with us with the technical issues last week. Gillian, thank you for agreeing to be my wing woman. Very capable.
No problem. Anytime. Happy to do it again.
Thanks to everybody for joining. It was really great. Really enjoyed it.
Yeah, enjoy your day. Enjoy the sunshine, guys, while we
Yes,
still
take
have it.
care.
Okay, bye now. Bye
Bye.
bye. Bye bye.